May it please the court, my name is Isaac Yu, and I, along with my co-counsel Brandon Fantine, represent the petitioner in today's case, the New York Rifle and Pistol Association. The question presented before the court today is whether the state's denial of petitioner's applications for concealed carry licenses for self-defense violated the Second Amendment. We will do so in 3 points. 1. The existence of the special need requirement causes New York Penal Law Code to be unconstitutional, as it cannot be examined under any form of judicial scrutiny. 2. English common law tradition and American laws enacted in both the days of the Founding Fathers and the 19th century firmly established the right to bear arms in self-defense. And 3. Under a pre-ratification review, the home and hearth requirement of Heller is not constitutionally applied, does not employ proper definition of self-defense, and creates a slippery slope fallacy. Regardless of constitutionality, this requirement is still dicta. To begin, I will pass it off to my co-counsel, Brandon Fantine, to argue the first point.
The existence of the special need requirement causes New York Penal Law subsection 265.01 through 04 and 265.20A3 to be unconstitutional, as it cannot be examined under any form of judicial scrutiny.
On the matter of judicial scrutiny, counsel, what is the difference between strict scrutiny, intermediate scrutiny, and rational basis review?
Well, Your Honor, strict scrutiny is the highest level of judicial review, requiring that all laws and regulation be narrowly tailored to a compelling governmental interest. Intermediate is the next lower level, requiring laws or regulations to be substantially related to a legitimate government interest. Rational basis is the lowest level of scrutiny, in which it just requires laws and regulations to be rationally related to the freedom that they are trying to protect. However, it should be noted that rational basis cannot apply to any constitutional protections. The wording of the Second Amendment is plain. A well-regulated militia, being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed.
Based on the plain text of the Second Amendment, what does the Second Amendment protect?
The Second Amendment protects the right to own and operate a firearm as it pertains to the defense of the state, which would be the militia. What the Second Amendment means is consistently debated. As the court has noted in prior cases, such as the District of Columbia v. Heller and McDonald v. City of Chicago, the amendment has been socially accepted as a right given to the individual, not the state or the nation. However, in the dissenting opinion from McDonald v. City of Chicago, a valid point is raised that the states historically have been able to regulate firearms due to their purview of police powers. However, in that same vein, legislative restrictions on firearms can only be imposed under the pretense of experimentation, as established in New State Ice. These experimental measures cannot be arbitrary, capricious, or unreasonable, as determined in Smith v. Robbins. New York Penal Law subsection 265.04, 01 through 04, and 265.20A3 directly contradicts this experimental requirement by instituting a just cause prong. Now, historically, no firearm legislation has had any level of scrutiny higher than intermediate. This was established multiple times throughout the court's history in Friedman, Heller, and Miller. The courts have instead looked to other tests to determine the efficacy of firearm legislation. Under every single form of analysis, however, the New York penal law in question is unconstitutional. Take Friedman, for example. Friedman v. City of Highland Park offers a different test for firearm legislation that falls outside of the traditional view of scrutiny. If a law would be deemed constitutional in the eyes of the framers and still propels the spirit of self-defense, it is constitutional. In the late 18th century, there would have been no special need for the people to show other than the need to hunt or protect their property or themselves from intruders or those who wish to do harm. By explicitly restricting the right to self-defense as it pertains to today's case, the New York statute in question fails that test proffered by Friedman. In U.S. v. Mazzarella, a similar test to that of Heller was used, which required a law in question to be reviewed under multiple types of scrutiny at once, whether these be rational and intermediate and strict, or strict and rational. The more restrictive the law, however, the higher the levels of scrutiny that needed to be implemented. The New York statute in question the efficacy of the law under a strict scrutiny review is minimal at best due to extreme regulation. The law is so generic in defining what just cause or special need is in relation to owning a firearm that it is not nearly narrowly tailored enough to pass that level of review. No specific instances of what would fulfill the special need requirement are listed in the statute, so as written, the law is unconstitutional as it limits a constitutional right and is generic in how you can pass the restriction. However, the lowest level of scrutiny, rational basis, would not even apply. Rational basis, as defined, is not just the standard of scrutiny, but is the very substance of the constitutional guarantee. Obviously, the same test cannot be used to evaluate the extent to which a legislature may regulate a specific enumerated right, be it freedom of speech, the guarantee against double jeopardy, the right to counsel, or the right to keep and bear arms. This quote, which was stated in United States v. Caroline Products Company, subcited in District of Columbia v. Heller, explicitly states that rational basis cannot apply to any law that goes to regulate a constitutional amendment or something written into the body of the Constitution. Now, although the court has argued in the past that New York Penal Law subsection 400 can fall under intermediate scrutiny and pass, as seen in Kolchalski v. County of Westchester, the New York statute in question cannot pass intermediate scrutiny due to that same special need provision. New York state courts have defined just cause that would pass this special need requirement as target practice, hunting, or self-defense, as determined in O'Connor v. Scarpino, cited in Kolchalski v. County of Westchester. The cause for self-defense was demonstrated by the plaintiff. By restricting rights with this special need clause to not include something the courts have previously justified as just cause, the state forfeits the right to a lesser review as the restriction goes far beyond any generalization that Heller allows for. Or in other terms, the general applicability that allows other legislation to be reviewed under intermediate scrutiny. I now turn over my argument to my co-counsel, Isaac Yu. Counselor, before you move on with your argument, how should the courts go about determining if gun control regulation should be considered long-standing?
Well, if you looked at the historical context, Your Honor, throughout English common law history to early founding era American law, and throughout the 19th century legal precedent, it's been clear that the right to bear arms has been repeatedly upheld throughout countless challenges to such a law. To proceed with our second point, English common law tradition and American law, enacted in both the days of the founding fathers and the 19th century, firmly established a right to bear arms in self-defense. English common law establishing the right of the people to use arms for various purposes from the beginning, from its earliest onset. The primal instance of this explicit right is in the 1689 English Bill of Rights, which states, "The subjects which are Protestants may have arms for their defense, suitable to their conditions, and as allowed by law." However, as one 1843 Parliament member once stated, by the Bill of Rights, the right to carry arms for self-defense was not created, but declared as of old existence.
Well, Counselor, what are arms?
Arms are any form of instrument that could be used in to do harm.
Now on to our final argument. Under a pre-ratification review, the home and hearth requirement established in Heller is not constitutionally applied, does not employ a proper definition of self-defense, and creates a slippery slope fallacy. But regardless of this constitutionality, or lack thereof, the requirement is still dicta. The right to self-defense is inalienable and applies to all places and all times under a post-ratification review. So under the purview of citizens at the time of ratification, defense and the resulting idea of self-defense are rights that must always be guaranteed by the government. Heller's establishment of a time, place, and manner restriction on defense does not uphold that intention of the framers. Under a pre-ratification definition, the right to defend oneself is inalienable. As referenced under the pseudonym Brutus in New York Journal, as collected by the New York's Ratification of Constitution with Proposed Amendments from 1788, the right of enjoying and defending life are of such a nature that they cannot be surrendered. Defense, in a general sense, was considered a power that the government could not infringe upon. Self-defense, being an extension of that broader umbrella term, would therefore be the unregulable defending life of the individual, as discerned from the etymology of self and the prior analyzation of the right to protect, or in other words, defense. The Second Amendment, as designed, is therefore meant to guarantee the right of protection, as it is the only piece of constitutional body that deals with the aforementioned rights of the physically endangered. Since Heller creates an aforementioned time, place, and manner restriction on the Second Amendment through the use of a firearm for self-defense purposes being delegated to only the home, in a time where a perceived threat exists, and with only a weapon that can be easily utilized by the military, as established in Saitano v. Massachusetts, which did subcite Heller, the intended right to self-defense that is meant to be protected by the government is not upheld. Under that analysis, Heller's in-the-home restriction does not fall in line with constitutional intention, and therefore should not apply in any regard. But translating this idea into New York Penal Law subsection 400, self-defense would be a valid reason for owning and operating a firearm in a public capacity. The need to defend oneself at all times is something that cannot be restricted without going against constitutional aims, and therefore New York Penal Law subsection 400 and the additional statute in question, if the Heller restriction did not apply, does reach beyond the boundaries of individual and state, discerned from the history behind the...
To proceed with our second point, English common law tradition and American laws enacted in both the days of the Founding Fathers and the 19th century firmly established a right to bear arms in self-defense. The right to bear arms was a foundational principle of English common law from its early onset. The primal instance of this explicit right is in the 1689 English Bill of Rights, which states, "The subjects which are Protestants may have arms for a defense suitable to their conditions and is allowed by law." However, as one 1843 Parliament member once stated, by the Bill of Rights, the right to carry arms for self-defense was not created, but declared as of old existence.
Well, Counselor, what are arms?
Well, Your Honor, arms are any object that can be used in one's defense or as a weapon. Thus, as a continuation of the English Bill of Rights, the Second Amendment merely codified what early Americans recognized as a pre-existing right. We can trace the existence of the English right to self-defense to the legendary King Alfred the Great, who, always afraid of the possibility of invasion by Danish Viking raiders, initiated the formation of an English militia, which was founded on the idea that all the free men were to be armed, trained, and ready to fight to defend their local and national communities.
What is a militia, and why did the framers refer to it in the Second Amendment, Counselor?
Well, a militia is a group of citizens designated to bear arms and fight for the defense of the state. And just like King Alfred, the Founding Fathers had no official army to defend themselves against a foreign threat, in this case being the Crown, the British Crown. Therefore, they found it necessary to include such a article in the Second Amendment. As part of this effort, Alfred vested new powers into the people and the sheriffs he assigned to keep the peace and protect the kingdom, in which English citizens were legally enabled and obliged to defend themselves and their property, self-defense, aid sheriffs in maintaining the peace when called upon, posse comitatus, pursue fleeing criminals, hear and cry, and conduct regular patrols, watch and ward. In order to properly fulfill these new duties, policies were enacted to ensure that citizens were supplied with weapons that they were bound to keep and be expert in the use of the arms they were obliged to possess. Men were to practice first with the longbow and later the musket. These pre-Norman Anglo-Saxon traditions and institutions, recorded as early as 878 AD, are what the United States v. Miller recognizes as the historical basis of the well-regulated militia clause of the Second Amendment. While certain decrees like the Statute of Northampton of 1328 state that no man, great nor small, of what condition soever he be, may come before the king's justices or other of the king's ministers during their office with force and arms, nor bring no force in a fray of the peace, nor to go nor ride armed by night or by day in fairs, markets, nor in the presence of the justices or other ministers, nor in no part elsewhere. it is widely established that this rule has no effect on English common law or the Second Amendment. As Rogers v. Gruel clearly states, from the beginning, the scope of the Statute of Northampton was unclear. While on its face, one clause of the statute could be read as a sweeping ban on the carrying of arms, both the history and enforcement of the statute reveal that it created a far more limited restriction. The Statute of Northampton was issued in a period of English history rife with political violence and domestic unrest, and was aimed to quell these violent insurrections from occurring and not inhibit the common man from bearing a weapon to defend himself. In fact, most of the time routinely carried the most common arm, a knife, for a myriad of purposes, and knives were necessarily available for self-defense in an emergency. As the Statute of Northampton was hardly enforced in England at the time of enactment, there is little reason as to why it should dictate the discussion surrounding American Second Amendment law today. The totality of English common law tradition throughout its history clearly demonstrates the protection of the right to bear arms, especially in regard to self-defense. Secondly, moving on to colonial and founding era American law, the English common law tradition mentioned previously also had a significant impact on the founding fathers' interpretation of the right to bear arms as well. In order to best understand the founders' interpretation and understanding of individual rights, we must turn to William Blackstone's Commentaries on the Laws of England, in which he boils down fundamental English rights into three core principles. 1, the right of personal security. 2, the right of personal liberty. And 3, the right of private property. He goes on to elaborate, claiming that other auxiliary subordinate rights of the subject, like the right to possess and carry arms, serve principally as barriers to protect and maintain and violate the three great primary rights of personal security, personal liberty, and private property.
So why did the framers even include the Second Amendment in the Bill of Rights?
Well, Your Honor, as established previously, they had this right to bear arms was ingrained in them as Englishmen. As English subjects, they always had the right to bear arms, and they found it necessary to include that to guarantee such a right in the new country. Blackstone's work was highly influential, as his work immediately became the great authority on English common law in both England and America, and constituted the preeminent authority of English law for the founding generation, as Aldwin v. Morwick states. As a result, no American law during either the colonial or founding period outlawed the wielding of firearms. The strictest measures enacted during this period either prohibited the carry of weapons other than firearms, or banned the use of armaments to incite violence and arrest, not for peaceful self-defense. See New Hampshire Laws 1 and 1692 Massachusetts Law number 6. If anything, many colonies and states required the use of firearms by law, a fact that District of Columbia v. Heller acknowledges, as many colonial statutes required individual arm bearing for public safety reasons. This right to bear arms in their own defense, one ingrained in them by their status as Englishmen, was one of the foundational reasons for the American Revolution. The Declaration of Independence lists the presence of standing armies without the consent of our legislatures as a threat that they impose, and the threat that they impose on the colonists as one of the most significant grievances that they had against the British Crown. And the Massachusetts Declaration of Rights expresses the colonists' understanding the people have a right to keep and bear arms for the common defense. This sentiment was carried through after the Revolutionary War and made it into the debates that occurred during the framing of the Constitution and thereafter. James Madison said, "The ultimate authority resides in the people alone. The advantages of being armed, which the Americans possess over the people of almost every other nation, forms a barrier against the enterprises of ambition, more insurmountable than any of which a simple government of any form can admit of," in his Federalist number 46. The unnamed author of Anti-Federalist number 28 stated that a well-regulated militia composed of the yeomanry of the country have ever been considered as a bulwark of the free people. Thomas Jefferson himself later declared that it is their right, the people's right, and duty to be at all times armed. While James Wilson declared that in the Pennsylvania Constitution, the great natural law of self-preservation constitutes the right of the citizens to bear arms in the defense of themselves. These sentiments can be encapsulated by Chancellor Kent. The right of self-defense is founded on the law of nature and is not and cannot be superseded by the law of society, in his Commentaries on American law. While influenced heavily by English tradition, the American founding fathers went even further and expanded the right to bear arms beyond the extent of the English forefathers. Thomas Cooley notes that the Second Amendment was adopted with some modification and enlargement from the English Bill of Rights. And as first federal Congress representative, James Jackson once said, every citizen was not only entitled to carry arms, but also in duty bound to perfect himself in the use of them. And ultimately, the Founding Fathers themselves enjoyed this liberty to carry arms in their everyday lives. John Adams had took a hunting rifle with him to school, Patrick Henry carried a musket on his way to court, and Thomas Jefferson holstered Turkish pistols in his carriage. Through this wealth of evidence, it is abundantly clear that not only did the founders continue the tradition of the English right to arms, but expanded upon it, from merely having arms to keeping and bearing them as well.
Well, Counselor, to elaborate on that final point, what is the difference, if any, between the verbs keep and bear?
Well, keeping, Your Honor, is to merely have possession of the weapon. However, bearing means to actively wield the weapon, actively use a weapon, whether it be by carry or by shooting. And finally, to move on, we must look at 19th century American precedent, which further established this legal tradition and respected the bounds of the Second Amendment. And despite this clear historical tradition established by both English practice and the Founding Fathers, the first challenges to the Second Amendment came as early as 1813, where the states of Kentucky and Louisiana banned concealed carry. The Kentucky ban in particular eventually was contested all the way to the Kentucky Supreme Court, which held in Bliss v. Commonwealth that in principle, there is no difference between a law prohibiting the wearing of concealed arms and a law forbidding the wearing, such as are exposed. And if the former be unconstitutional, the latter must be so likewise. An Alabama state court case, State v. Reed, which did uphold the concealed carry ban, only did so on the basis that the right to enact laws in regard to the manner in which arms shall be borne, as may be dictated by the safety of the people and the advancement of public morals, and clearly stated that any statute which, under the pretense of regulating, amounts to be a destruction of the right, or which requires arms to be borne as to render them wholly useless for the purpose of defense, would be clearly unconstitutional. A Louisiana state case, State v. Chandler, considered open carry to be protected as Second Amendment. Later cases protected by the Second Amendment. And later cases, such as State v. Jumel, interpreted the former's holding as only prohibiting only a particular mode of bearing arms, which is found dangerous to the peace of society. The aforementioned 19th century cases, all cited in Heller, concur with the overarching themes seen throughout the English and American legal tradition. The right to bear arms is not to be hindered.
Well, Counselor, how should the courts go about determining if gun control regulation is considered long-standing?
Well, Your Honor, for a tradition to be considered long-standing, we must look at the historical context of this, as I clearly established throughout English common law, early founding father, the founding era, American law, and throughout the 19th century. The right to bear arms has been repeatedly upheld throughout. Therefore, it should be considered a long-standing tradition.
The Second Amendment.
Quick point of clarification, counsel. Is there a difference between openly carrying a firearm and concealed carrying one?
Although there is a difference between open carry and concealed carry, regardless of if the firearms in question were proffered for an open carry purpose or a concealed carry purpose, the New York statute in question does still overreach, as mentioned by the special need requirement, and additionally the home and hearth requirement established by Heller that the statute in question uses as a supportive beam does not stand under any form of review or analyzation. So under a post-ratification definition, the home and hearth requirement overly burdens the historically accepted right of self-defense. Self-defense, as defined in Heller, does not match up with a post-ratification definition of self-defense implied in multiple historical documents. As a result, the very same opinion found in Heller that influenced the respondent's merit brief is unfounded. The District of Columbia v. Heller established the precedent that the Second Amendment has specific restrictions in and outside the home. More specifically, a ban on handgun possession in the home violates the Second Amendment, as does its prohibition against rendering any lawful firearm in the home operable for the purpose of immediate self-defense. Under a textual analysis of Heller, a self-defense exception to carrying and holding a firearm only applies to the home in the case of immediate self-defense. However, the meaning of self-defense is not established in Heller. Looking to a post-ratification definition of the term, It is a combination of protecting oneself from an oncoming threat, as elaborated on in commentaries of American law and the Constitution of Pennsylvania. Self-defense lies within the grounds of self-preservation, as the ability to defend oneself from a perceived threat is a natural right. Under that definition, self-defense is only restricted to not be excessive to the point where it goes beyond protection and starts to inflict harm, and it must explicitly relate to the protection of one's own body, regardless of spatial location. Respondent's merit brief is correct in the assertion that, like all constitutional rights, the right to carry firearms for self-defense is not unlimited, but rather incorporates the limitations embedded within the historical understanding of the scope of the right. Heller, attributing self-defense to be only the protection of oneself in one's homestead, does not fall within the confines of prior historical definition. Instead, it is solely a restrictor that amalgamates personal and property interests. One can only protect themselves if they are tangentially protecting the physical space in which they reside. Under this definition that Heller employs, it's not self-defense in the sense of the word. Instead, it's a form of property protection. The limitation imposed is nowhere near what self-defense has been historically assumed to constitute, and therefore it is incapable of being a Second Amendment restriction under Heller's own definition of self-defense limitations that respondent employs to justify the New York Penal Law subsection 265.01 through 04 and 265.20A3. Heller's home and hearth requirement also creates a slippery slope fallacy. The Second Amendment guarantees the right to bear arms to all people. Heller's home and hearth requirement categorically excludes those without property interest, thereby making the requirement and the fruit of that ruling at conflict with the Second Amendment itself. In the U.S., there is roughly 600,000 homeless men, women, and children, with 39% of those being unsheltered. This is the most recent statistic that was uncovered in the U.S. Housing and Department of Urban Development 2020 census. But more specifically, the state of New York has the second highest homeless population, with roughly 466 people per 100,000 citizens. Heller's home and hearth requirement excludes all these naturalized or U.S.-born citizens. The nearly 600,000 homeless people living in the U.S. have no property interest in any form. As defined, the home and hearth requirement requires an interest or ownership in the property to exist before a firearm can be used in self-defense. By instituting a property right for something guaranteed by the Constitution, a similar situation of categorical ignorance akin to that of the pre-Civil War era is established. People are denied certain rights that establish a higher quality of life, that higher quality being the fruit of protection and self-defense, via discrimination stemming from factors that they cannot physically control. The in-the-home requirements for self-defense firearms does discriminate against the homeless population and therefore is against the Equal Protection Clause of the 14th Amendment. As a result, that limitation on the Second Amendment is unconstitutional, and future rulings hinged on the existence of such a requirement, such as Kachalski v. County of Westchester, that the respondent uses to justify the penal law in question, are based off an inherently unconstitutional and inapplicable line of reasoning. This creates a slippery slope fallacy with sweeping restrictions on the right to bear arms. If the property requirement cannot apply, other broad restrictions to firearm ownership in all public spaces cannot apply either. If there is no sweeping restriction, firearms can be carried for the purposes of self-defense. Now, this does not necessarily mean that they can be carried in all places at all times. The state still has full purview to restrict aspects of firearms, but as established in Jackson v. City of San Francisco, the state only has the right to establish restrictions that curb local gun violence and the relative danger of firearms. New York Penal Law subsection 265.01 through 04 and 265.20A3 does neither. Instead, it exists solely to prevent gun ownership, not lethality. The fallacy, therefore, fractures the law in question, and as written, the statute establishes excessive restrictions that are not logically supported via Heller and the rulings it inspired. The home and hearth language in Heller is also non-binding dicta. Dicta, as defined by the 10th Circuit in In re Tuttle, is statements and comments in an opinion concerning some rule of law or legal proposition not necessarily involved nor essential to determination of the case at hand. In the court opinion for Heller, any mention of restrictions on where firearms can and cannot be held is dicta under that definition. In Heller, the only issue presented to the court was whether the law implemented by the District of Columbia requiring unlicensed firearms to be made inoperable in the home violated the Second Amendment. Ownership of firearms was not contested in this case. Rather, the restrictions placed on said ownership after a gun had been acquired. Generating a broad ruling that firearms for the use of self-defense can only be present in the home is not tangentially related to the question of if those additional restrictions implemented by DC were constitutional. With all this considered, the home and hearth rule would be considered dicta under this very definition that was affirmed in Humphrey's Executor v. United States and Central Virginia Community College v. Katz. Therefore, the requirement does not have to be adhered to in any regard. In conclusion, the precedents established by this court regarding this matter are apparent. The government cannot infringe on the right to bear arms in self-defense, as per the Second Amendment. The historical precedent established all the way from English common law tradition to American legal policies, enacted from the founding onwards, adamantly defend the right to bear arms in self-defense, one that Heller established in this court's precedent. If the court were to overturn existing precedent and go against centuries of well-established legal tradition, it would create a slippery slope in which the issue of self-defense, in a time at which violent crime proves to be a pertinent threat to many, especially for traditionally marginalized minorities, as established by the amicus curiae brief by the DC Project Foundation, Operation Blazing Sword, Pink Pistols, Jews for the Preservation of Firearms Ownership in support of petitioners. And hindering individuals from bearing weapons may, in turn, do more harm than good. As Cesare Beccario puts it, laws that forbid the carrying of arms disarm only those who are neither inclined nor determined to commit crimes. Such laws make things worse for the assaulted and better for the assailants. They serve rather to encourage than prevent homicides, and for an unarmed man may be attacked with greater confidence than an armed one. In conclusion, the precedents established by this court regarding this matter are apparent. The government cannot infringe on the right to bear arms in self-defense as per the Second Amendment. The historical precedent established all the way from English common law tradition to American legal policies enacted from the founding onwards adamantly defend the right to bear arms in self-defense. In overly restrictive laws like the home and hearth requirement established in Heller or the New York statute in question do not uphold this spirit of self-defense and are unconstitutional. If this court was to overturn existing precedent and go against centuries of well-established legal tradition, it would create a slippery slope in the issue of self-defense, in a time at which violent crime proves to be a pertinent threat to many, especially traditionally marginalized minorities, such as women, members of the Jewish faith, and members of the LGBTQI+ community. Hindering individuals from bearing weapons may, in turn, do more harm than good.
Well, counsel, how should the court consider the public safety implications of licenses to carry firearms then?
Although there should be some regulations such as licensing or background checks to regulate firearms, total regulations such as that seen in the New York statute in question only hurt the people more than it helps the people. As Cesare Beccario put it, laws that forbid the carrying of arms disarm only those who are neither inclined nor determined to commit crimes. Such laws make things worse for the assaulted and better for the assailants. They serve rather to encourage than prevent homicides, for an unarmed man may be attacked with greater confidence than an armed one. Therefore, it is our contention that New York Penal Law subsection 265.01 through 04 and 265.20A3, along with New York Penal Code subsection 400, is in clear violation of the Second Amendment and should be deemed unconstitutional by this court.
One final point of clarification, counsel. What are the limits of the Second Amendment's protections then?
Second Amendment protections are explicitly stated in the amendment itself. It provides the right of the people to own weapons and use those weapons. However, they may still be held liable for the consequences of using those weapons. Taking away the right to own firearms in general does not uphold the purpose of defense that is behind the Second Amendment. Your Honor, it is for these reasons we pray that you rule in favor of the petitioner in today's case, the New York Pistol and Rifle Association.